Hello everyone. Today we are going to discuss the hierarchy of criminal courts in India as per the provisions of the Bharatiya Nagarik Suraksha Sanhita 2023, that is the BNSS. Now, of course, if we look at the chart here on the screen, we can see that the Supreme Court is the highest criminal court in India. The Supreme Court has an appellate jurisdiction over criminal matters as per Article 134 of the Indian Constitution. Now, in criminal cases, an appeal lies to the Supreme Court of India if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to either death or imprisonment for life or for a period not less than 10 years, or if the High Court has withdrawn for trial before itself any case from any court subordinate to it and has in that trial convicted the accused person and sentenced him to death, imprisonment for life, or a term not less than 10 years. And thirdly, it has been certified that the case is fit for appeal to the Supreme Court by the High Court. Right. So in these cases, we see that the Supreme Court of India has appellate jurisdiction over criminal matters. Apart from the Supreme Court of India, the High Court has original jurisdiction, appellate jurisdiction, as well as the revisionary jurisdiction. So the High Court has the power to try any offence under the BNS or any other law that does not specify a specific court for trial. It also has appellate jurisdiction, which means that the High Court can hear appeals against decisions made by subordinate courts in criminal as well as in civil matters. And then we have the revisionary jurisdiction, which allows the High Court to review the decisions of subordinate courts in civil as well as in criminal matters, right? So that is the basic of the powers of the Supreme Court and the High Court. Then, when we look at the structure properly, apart from what has been established at the national and state level, we see that at a district level, the highest court is the Court of Sessions, which is followed by the Court of Chief Judicial Magistrate, and then we have Judicial Magistrate Class 1 and Judicial Magistrate Class 2. A judicial magistrate may also be appointed as a special judicial magistrate to try a special case or a special class of cases. Now, what is missing here is metropolitan magistrates. Now, the CRPC under Section 2K defined metropolitan areas, and also under Section 16, 17, 18, 19 spoke about metropolitan magistrates and their courts. We had provisions for, metropolitan magistrates, chief metropolitan magistrates, additional metropolitan magistrates, special metropolitan magistrates, their subordination, and all of that. But those provisions are no longer present here. So now we only have what has been mentioned here. So Supreme Court, High Court, followed by the Court of Sessions, Court of Chief Judicial Magistrate, Judicial Magistrate Class 1, Judicial Magistrate Class 2, and there may be a Special Judicial Magistrate who is usually a Judicial Magistrate Class 1 dealing with a special case or a special class of cases. Now, if we look at the powers, what is it that these courts can do and what is their hierarchy, right? The first is the High Court. So, of course, the High Court can pass any sentence authorized by law. Then we have Sessions Judge. So, as we saw, the Sessions Court is presided over by the Sessions Judge or the Additional Sessions Judge. Now, additional sessions judges are appointed to assist the sessions judge. Now, the sessions judge may have a lot of burden, and to assist him, additional sessions judges are appointed. Whenever additional sessions judge is appointed, they have the same power as the sessions judge. So, any sentence authorized by law can be passed by a sessions judge or even an additional sessions judge, but if they pass a death sentence, that has to be approved by the High Court. Then we have section 23, which talks about the powers of Chief Judicial Magistrate and Additional Chief Judicial Magistrate. They also have the same powers. Whatever powers and functions have been accorded to CJM have also been accorded to the additional chief judicial magistrate, and it is up to 7 years. So any offences that are punishable with imprisonment up to 7 years can be tried by the chief judicial magistrate. Judicial magistrate class 1 deals with offences that are punishable with imprisonment up to 3 years. Now this amount and fine up to 50,000 rupees, right? So this used to be 10,000 rupees under the CRPC and has now been increased to 50,000 rupees. Similarly, for the judicial magistrate class 2, imprisonment up to 1 years and fine up to 10,000 rupees, right? So this used to be 5,000 rupees under the CRPC and has now been increased to 10,000 rupees. This increase has taken place because the BNS has increased the amount of fine for several offences, right? And therefore, it is necessary to increase the powers of the judicial magistrate class 1 and judicial magistrate class 2. We also see an additional form of punishment under the BNS, which is community service. Now, community service has been explained as court order work that benefits the community, which is for which you're not entitled to any remuneration. Now, this has been provided as an explanation to section 23. The idea behind introducing community service is to decrease the population in the prison and also adopt a more rehabilitative and reformative approach to punishment. And that's why we see for several offenses now we have not only imprisonment and fine as punishment, but community service has also been added. So these are all the sections that we will be looking at today. Of course, there is a lot that is going on, but we are primarily trying to just establish the structure. Now, if we go back to the hierarchy, we also see the hierarchy of executive magistrates. So what we saw so far was the hierarchy of judicial magistrates, right? So hierarchy of executive magistrates is also extremely essential. Now, executive magistrates are magistrates who are appointed for administrative tasks, right? Now, but we also see that under the BNSS and even under the CRPC, executive magistrates had extensive powers. Now, in order to exercise those powers, we see that executive magistrates are appointed and a certain hierarchy is created. Now, executive magistrate in every district, the state government can appoint as many persons as it thinks fit to be an executive magistrate, and one of them will be a district magistrate, right? So, district magistrate is on the top. And then there may be additional magistrates if required, right? So, if it is not enough, then we can also appoint additional district magistrates. Then the other magistrates, apart from the district magistrate and additional district magistrates, are all executive magistrates. The state government may also appoint in a certain subdivision a subdivisional executive magistrate who will only deal with the matters of that subdivision, and where a subdivisional executive magistrate has been appointed, only that subdivisional executive magistrate will deal with the matter. Similarly, we have special executive magistrates provided under section 15. Now, special executive magistrates again deal with particular areas or perform particular functions that the state government specifies. So we don't see a specific function allotted to them under the BNSS. It has been the power has been given to the state government to appoint as many special executive magistrates as may be required for particular areas or for performance of particular functions, and that again will be determined by the state government itself, right? So these are all the sections that we will be looking at today, and post that we will go ahead with public prosecutors in the next class. Thank you so much.